Welcome back, everybody, for another episode of California Labor Law Odyssey. The one show, maybe the only show, that brings attention to the ever-growing, over-bloated 1,000-page labor law digest here in the state of California. And the predators, the carnivores out there feeding upon it, finding simple mistakes and turning them into multi-million-dollar fines for small and big businesses alike here in the state of California. As hosted by a man who knows all too well his company's been hit, formed an organization to fight back. Tom Manzo. Hey, Tom.
Hey, good morning, Paul. How are you today?
Angry. I'm always angry when you come in.
I don't know what that is.
This crazy law, Private Attorney General Act, which only California has, allows ordinary people to sue their boss, not just on behalf of themselves, but a whole category of fellow employees, and on behalf of the state of California. It claims we don't have enough time, attention, money to do this, so they sort of deputize. They empower ordinary people to go sue on their behalf, and then they swoop in and take 75% of whatever the settlement, the fine is. And if that isn't bad enough, there's a whole cottage industry of attorneys and accountants who have sprung up to bring these actions against small and big businesses or to defend them. And it's the only law in the world where there's no remedy except pay. You can't fix it and avoid a fine. This isn't a fix-it ticket. And you're guilty the minute you get found. You don't have to prove you were wrong. You don't have to prove there's any harm. It can be just the
guilty until proven guilty.
Minor violation leads to millions of dollars in fines. And faced with this, businesses like yours just pony up and pay and hope it never happens again, right?
Yeah, absolutely. And we have our VIP guest co-host. I call him our co-host now.
Because we went through the last episode why first you were frustrated to find this happens, angry. Then you found others who had equally been angry but were afraid to step forward. You formed an organization called?
CABIA, C-A-B-I-A, California Business and Industrial Alliance.
And how long ago did you found this?
About a year and a half ago.
Year and a half ago or so, and you've already got couple hundred people or whatever joined this
100
group.
members, we need more.
There you go.
Lots more.
And so first you went to the state and to legislators and said, let's see if we can't fix this. Let's see if we can't bring it to their attention because nobody's talking about it. Let's see if we can for some way to fight this, but there are powerful groups allied against it, trial lawyers, unions, others. And out of frustration, you decided to what? File a lawsuit.
We filed a lawsuit.
Against the state of California.
For not doing their job.
Well, and for allowing this to go on far too long. What may have been a well-intentioned law has turned into a extortion scheme.
Absolutely.
And I don't say that lightly or simply. Because, as in your case and so many others, when you get found, when a violation is brought forth, there's no fix-it. There's nothing else. There's almost no way to defend this, right?
It's all settled in mediation, all of them.
And it's all, and the only thing you're mediating is how much.
Yeah. Absolutely.
So, out of frustration, out of refusing to go away and just let this go on, you filed a lawsuit against the state, and today we're going to discuss that lawsuit in detail with your lead attorney here.
Yeah. With Rob. Rob, you want to introduce yourself really quick?
Yeah, Rob Pepple. I am an attorney at Epstein, Becker & Green. I'm also legal counsel for CABIA, and just happy to be along for Tom's ride.
And you have been and continue to be an attorney of a law firm that fights these on behalf of businesses.
That's correct, and we're proud to do it.
And
proud
yet,
to be on the right side of the law.
And yet you even admit that
they wear the white hats.
In so many cases, the best advice is don't fight it, just pay up. Hope it doesn't hit again.
More often than I'd like to say yes, it is a better business judgment call to settle the lawsuit.
It's bad law, and it's a bad precedent, and it allows bad behavior to continue, but the best course is often just roll over and take it, pay your money, take your medicine and move on.
Well, before we get into
the lawsuit,
I want to just touch briefly. So last Wednesday we filed the complaint
here in Orange County.
And we held a press conference rally.
Pretty amazing at the old courthouse over in downtown San Diego.
That old courthouse is beautiful. Very nice place.
Yeah, if you've never seen it, go look it up. It's a classical. It's where everybody does.
1901.
It's where everybody files these photo op kinds of things. And there you guys were with your signs like the one behind you, and you had local representatives show up, local mayors, local media, And
I want to thank Don Wagner, Mayor of Irvine. He came and spoke.
Yeah, there you go.
Awesome job. We had Judge Stephen Bailey come and speak. Awesome job.
And out of this, what's the hope? What's the lawsuit? We want to break this down. We're going to take an hour, folks, so stick with us. We're going to break this down because it's important to understand. The last show was why file a lawsuit? Why not work through the legislator? Why not work through an initiative? Why not just find somebody else to take this ball and run with it? And when you couldn't, this seemed to be the only course of action available.
Well, one reason I love this show is because you get an opportunity to talk about what's really happening, because sometimes you just don't have enough time.
Never. Right.
You just don't have enough time. And I even asked Paul here, my co-host, I says, have you read the complaint?
And I promised I would before the show, and I started to, and I went, oh, my God, my head aches.
So what we're going to try to do is it's a 54-page complaint. We want to break it down in the event you don't have time to read it. You can listen to it on your way to work or on your way home from work.
Wrap your head around what this is and why they're doing it, what it is, and how it can hopefully fix.
Or if you're going to have like a romantic meal tonight, you know, have a steak, wine, and hold on, I want to listen to this podcast.
Play it in the background.
Play it in the background.
You want to go downstairs and have the coffee shop play it in the background here. This is just soothing information.
Idea.
All right, so give us the summary. What's the lawsuit?
Well, what I want to do is I want to read the synopsis, and once I read the synopsis, then I'm gonna turn it over to Rob.
And he's going to start breaking down what these 54 pages are all about.
Absolutely, but I think the synopsis is so important for people. So, our California business owners who inadvertently make payroll errors equivalent to the worst perpetrators of hate crimes.
Say that again. Just read that, because that's an
Our
inflammatory.
California business owners who inadvertently make a payroll error.
Inadvertently, no, they're not doing this because they're evil.
Equivalent to the worst perpetrators of hate crimes. Okay. Why am I saying that?
Yeah, right. That's a pretty.
Why am I saying that, Rob? Can you help me out on that?
Because that is the only justification that the California legislature, in its wisdom, found as basically a comparison to pass this law. This is an unfettered delegation of power to attorneys, and the only example they could find in state or federal
where they've
law,
given attorneys this much power,
private individuals the power of the state. Because keep in mind what PAGA does, and I'll back up in a minute. It basically puts people in the shoes of the state and gives them all the state's power. This has never been done before.
Power to investigate, power to prosecute, power to dig into your books and records.
Giving them a badge and a gun, for lack of a better word.
Right.
And the only example in all of the law
where they've done this,
it's under the Unruh Civil Rights Act, where if someone commits a hate crime, you have the right to sue on behalf of the state and collect $25,000 in penalties.
How many people are aware of that?
I wasn't.
All right, let me finish my synopsis here.
So you're now in the same. This is so heinous.
Late lunch is
there's a word.
crime.
Go look up heinous. So heinous, so awful what you guys are doing that the state has to empower private citizens just like they empower them to fight hate crimes.
Yeah.
All right.
So that's the twisted logic that more than a decade ago led the state legislature to pass a harmful law called the Private Attorneys General Act. PAGA was conceived as a means to help employees right workplace wrongs without further burdening the state bureaucracy.
Right.
Trial attorneys quickly discovered they could use the law for their own benefit. Today, thousands of PAGA complaints are filed annually against large and small businesses, nonprofit charities, and even labor unions.
Right.
PAGA, as written and practiced, is unconstitutional. So with this complaint, we're asking the state to enforce its own laws rather than transferring the state's power to private attorneys who operate for their own personal gain.
Extortionists. Wow. Okay, that's a powerful argument.
I think the person that should be charged for the hate crime is those attorneys that are suing good companies.
Yeah. Simply because they know they can hit and run. Because they don't even, that's one of the points. This is just like a slip and fall attorney. The worst example of attorneys we know are the ambulance chasers.
These are ambulance chasers.
They show up and it's a totally overblown, fabricated charge in so many cases. Not in everyone, but in so many we know. And all it is just shake you down and pay some money because it's simpler to pay
But it's not thousands.
than to
We're
fight.
talking millions.
Yeah, right. The typical hit and run's probably 10 grand. Somebody gets 10, 20,
Right.
30
The
grand.
typical hit and run with PAGA is about $1 million.
Yeah. That's just what angers me here.
Rob, let's break it down in layman's terms so we can all kind of understand.
What are you arguing? Let's make your argument. Lay out your arguments.
All right.
Page one.
I'm going to geek out for a minute, and Tom and Paul are going to be my regulators.
We're going to stop you when you say, what the hell are you talking about here?
So let's back up and let's talk about what the complaint is. We tried to fix it through the legislature. And again, the legislature, the assembly, the Senate, they get to make the laws.
Right.
So what do you do if you have a law that you can't get changed through that process?
No one will listen. No one. Well, a couple of them told you literally, don't even bother. Nobody's going to change. I'm sympathetic with you. I understand it's a problem. Nobody's going to change this. Too many people are profiting from it. Too many important people are powerful forces are for it.
So the only course of action then is to say, look, we can't get through the legislator. The courts aren't helping us. So we have to stop the arm of the government that enforces the law.
Has there been any pushback from courts? Most of the courts have seemingly been sympathetic to this, even when the arguments are, and I looked at some of the ones prior to this, cases where attorneys said, big companies said, this is stupid, this is ridiculous.
The law requires very little court involvement.
Most of it's a rubber stamp.
Most of it's a rubber stamp. So
because you're settling it somewhere else and they're just going to but
it's settled in mediation and they just take it and okay.
But I was shocked by some of the judges' statements where they said, how is this going to benefit the employees? This is $10 million, $50 million, $60 million, and 90% of it's going to attorneys and administrators and the state. How is this helping the employee? And they said, well, if that extra $5 helps somebody, you had one crazy example. You're always giving me one example. Some judge said something like that. If
$637.
And they said
they could buy groceries with that.
Yeah, so it was worth
over 4 years.
It was worth penalizing this company. How much? How many millions of dollars?
About $5 million, I think.
It was worth sticking somebody with a $5 million bill if that employee ends up with if each employee gets another $600.
Yes.
Yeah.
So, with all that said,
right.
The key is the only option is say we have to stop the enforcement arm of the government from enforcing this law, and that's what we've done. We have sued the Attorney General, the chief law enforcement officer of the state, to say, we're going to bind your hands from enforcing this law because it is unconstitutional. That is why the lawsuit is Cabia versus Xavier Becerra in his capacity as the Attorney General.
Okay.
So that's what we're doing.
And has he come out ever and publicly stated his position on this law? Is he for
No,
or against it? Does he even acknowledge it or talk about it?
He probably doesn't even know what it is.
So we don't
I didn't know what it was. I'm not going to blame him. I don't think most of us know what it is. Yeah.
So that's what we're doing, okay?
Right.
And the complaint is to basically tie his hands, and we've done that on constitutional grounds, under the federal Constitution and the California Constitution.
And that's interesting because that's a different thing than just saying this is wrong, that it's unfair, that it's unequally applied. You're saying it's unconstitutional.
Well, for all those reasons.
Oh, okay.
Again, because the legislature is within their legislature can pass any law they want, just any law that's not against the Constitution.
Right. Clearly.
That's the only grounds to challenge it because they have broad latitude to pass
they
whatever law they want.
If they say you can't wear color blue or color red because we're a blue state, if you can't wear the color red in California anymore here,
that would probably be fine.
That'd probably be fine. As crazy as that is, that's probably fine.
So that's what we've done, and that's the only avenue available to us. And so what this complaint does is it's attempting to prevent the enforcement arm of the government from enforcing this law. Now, we're going to have to go back and do some basics here, okay? The Private Attorneys General Act is not meal breaks, not rest breaks, not pay stubs. It is the government's enforcement of those penalties on top of the laws that already
allowing
exist.
Ordinary people to be deputized, basically, to get a badge.
But they already
and
can do it, Paul. They already can do it. They're already allowed to sue for rest breaks. They're already allowed to sue for meal breaks. They're already allowed to sue for pay stubs. They have their own remedies privately. You get your attorney, you do a class action. This lawsuit is not aimed at stopping that. What this lawsuit is aimed at is not allowing private attorneys, basically I say private attorneys, it's really them driving the lawsuits, to step into the role of the state. Because when the state is a party in a lawsuit, they always win. The procedures are different. There are different rules for the state because it's the state. And I'm going to get into all those different rules.
They certainly have more power to force your books open until, because that's one of the things that Tom talked about, the so-called stacking. So you come in, they find one violation or they think there's a violation, and then with the power of the state, they start this fishing expedition through your books, which costs you major money to comply with and open up and do this. And in the course, they find 10 other things. They think 10 other minor violations, and they stack them up. And then the combined penalty is so big, you settle.
Correct. And so what the state has done is they've said, okay, private litigant, private attorney, you have the power of the state. Now, let's use an analogy. Let's say we're in criminal court and you had an attorney, you say, I'm going to give you $100 an hour if you do not convict this person of a crime, or $300 an hour if you do convict this of a crime. That seems wrong, doesn't it? Because, because what is the state supposed to be doing? A state attorney is supposed to pursue justice.
Yeah.
Right? That monetary motive seems wrong.
Right.
And that's what they've done here, and that is the theory of our lawsuit. When you give state power to someone, the state's supposed to pursue justice, not money. And so in doing that without any oversight whatsoever, and that's the key, that is the core of this lawsuit.
Yeah, there's no, they go off on their own and then they just show up and hand the state their chunk of the cash they've collected.
And so that is the core of the lawsuit, is that if you're going to hand this power to a private litigant, a private attorney, you got to keep an eye on these guys because we know what they're after. They're after their own pocketbook.
Right.
So we have the introduction of the complaint. I'm going to walk through structurally the complaint so we get through all the important parts.
Good.
All right.
So the introduction itself has a bunch of basic overriding facts. I will direct people's attention, if you can, just to page 1, paragraph 3. This is why PAGA litigation is so problematic. And if you know anything about litigation, this will make sense. Even if you don't, this will still make sense. In most...
I'm going to put on my glasses.
In almost every single employee out there has an arbitration agreement. An arbitration agreement is an agreement between you and your employer that if you guys get into a tussle, a tiff, you guys are going to go to court, you go to arbitration. It's cheaper, it's faster, it's better.
Right.
Now,
and it's better for the state because it doesn't clog the courts with things that can be decided outside of the court. Right.
In a PAGA lawsuit, those don't apply because it's on behalf of the state and the state didn't agree. That's already a problem.
Say that again. So the state didn't agree to settle this through arbitration.
Exactly.
And they're part of the litigants.
Even though the employee is the one bringing it, and truly the state has no involvement, they don't pay attention, because the state didn't sign that arbitration agreement, they don't apply.
So the employees did, the employer did, but the third party to this agreement, the state did not.
And the state is supposed to be involved.
Well, you would think so, and that's the core of the lawsuit.
Now, let me just stop for a second. I won't embarrass him by saying, but we had some big lawyer in here the other day from a major law firm, and he was talking about all the things to fear if you're an employer. He represents employers, and he said one of the first things you need to do, not just go through your pay stubs and make sure you're squeaky clean in these 1,000 things, which almost nobody is. It seems impossible not to make some minor error in accounting, in a typographical error. You got the wrong employee ID on the pay stub, and that's a violation. All these crazy things you've listed over the weeks here. He said, put an arbitration agreement in place.
With a class action waiver. I'm sure he said that as well.
May have.
And some of those arbitration agreements have been successful, some of them not, depending on how they're written. Correct, Rob?
Not against PAGA. There's a Supreme Court case, Iskanian, you can Google it, just like it sounds. It says that because the state did not agree to arbitrate, those agreements are not enforceable in a PAGA case.
Because the state is suing you, and they didn't agree to settle this in arbitration.
Exactly.
Yeah. So there's a lot of misnomers when it comes to arbitration.
Okay.
Is it Iskanian or Iskanian?
Just like cabia or cabia, we can argue.
Tomato or tomato?
Depends who says it more. So
anyway, go ahead, Rob.
Now,
Sorry.
and as Tom alluded to, and as most people know, most lawsuits are settled in mediation. I mean, we say that, we've thrown that term around. Let's define it. There are 3 ways that you can resolve a lawsuit. You can go to court. That's a court resolution. A judge says this is what happens.
And that's expensive because you got to pay for attorneys.
And there's arbitration. And an arbitrator says this is what happens. So that's important, guys.
And that still costs money, but less money theoretically.
But here's the difference. What the judge says goes. What the arbitrator says goes.
Right.
In mediation, it's 2 parties. It's voluntary. Anyone can walk out. A mediator cannot tell you what to do.
Yeah, no, they're just trying to see if we can make a deal here.
Make a deal. Let's be friends. So, and most things happen in mediation.
So you can litigate, arbitrate, or mediate.
Exactly.
All right.
Now, remember, this action is brought on behalf of the state.
Which is
like
what we do.
Now, exactly. Now, in these mediations, and 99% of the things get resolved in mediation, what ends up happening is that these private attorneys, they use PAGA to get you into mediation. Because think about it. If you were a single employee that had an arbitration agreement and a class action waiver, you can't represent everyone. You get your single individual case.
Right.
And that attorney doesn't want that case. They want everybody. They want that big group of people.
Because they make more money. They get a share. They're doing this on spec, and the We all know they work on contingency. You can't pay for their work, so they say we'll do it for free, and we get a share of the proceeds, like a third or some.
Exactly.
Right.
So they use PAGA to say, well, guess what? That arbitration agreement does not apply to me in my case. Let's go to mediation. Now, at mediation, what they do is they flip it. Because remember, PAGA is not about meal breaks and rest breaks. It's a penalty on top of meal breaks and rest breaks. The penalties already exist.
Right.
So they get to mediation and say, look, you have 4 years of penalties that could be brought against you.
And 14 other things we might find.
Exactly. So,
because we have the power of the state to go rip open and look for everything here.
and so these mediations, what they say is, well, look, let's settle for $1 million. But even though the only reason why we're here is PAGA, we're going to call 95% of that labor code violations, and we'll allocate $5,000 to PAGA.
And that's why we call it extortion, because they're coming in hoping that you're really not going to fight this thing. They don't have the time or talent or resources to do it. They want to hit and run. They're going to come in. They're going to try and scare you so much that you're going to pay up.
And guess what? Is the state at that mediation? No, they are not.
You think they should, because
And
they're
most
party to
times,
the lawsuit.
The employee is not even at the mediation. It's just the attorney.
Are they supposed to be?
You know what? We think it's an ethics violation not to even bring the representative employee, but in a lot of these, the employee does not even show up. In the last mediation I had, the employer, and I can't reveal what it was, it's privileged. He said,
Right.
you know what? I did not bring my individual employee because I didn't want you guys to settle with her alone. Because without her, he has no power of the
Has
state.
no suit.
Indeed, he said, I cannot resolve this case for the offer you guys have because I have to protect my referral source. The guy has no interest in the state.
My referral source. The person that turned me on to this has got to get a chunk of it too. And,
Exactly.
Right.
Straight up said it to us. And so those are the motivations at play. So obviously there's a broken system.
Because it's just for them. It's an ambulance chaser. I found an opportunity to hit you up with a quick settlement, and I'm banking that you'll take as big as it is, you'll take that settlement, because the potentials were, we talk about the Walmart case all the time where they didn't have seats for their cashiers. The potential threatened liability was $500 million. Walmart said, we'll pay the $65 million.
And here's the problem. If you're going to pay someone $300 an hour to convict someone of a crime, you're going to work harder to convict someone of a crime rather than do justice.
Well, yeah.
And that is why they saw constitutional.
Are we still on page 2?
We'll get there. We'll get there.
Wow.
So
you're empowering people to enforce justice, and all they want to do is line their pocketbooks.
right, among other unique things with the PAGA law is that in most cases, I'm sure every business owner here has incorporated, dotted their I's and crossed their T's.
Yeah.
And that protects you from liability. And indeed,
Personal liability.
And sometimes if someone sues you for too much money, you can claim bankruptcy.
Right.
Under PAGA, that does not matter.
What?
They can come after you personally. They can go right through the corporation. They can come after your savings, your college tuition funds. The fact that you have an organization has nothing to do with it.
PAGA
can-
reform now? You want me to hold my sign up? And
They
hang out?
can. No, I was just trying to keep them in the mic there. So
Oh.
you can. So all these things I did to protect myself from my business's liabilities do not apply.
They passed that law in 2016, I believe.
Well, that's a different law, but
Oh, that's another
But
one.
but here's why: because
More laws.
Because and again,
That's what we need, more laws.
and these are laws that typically only the state's allowed to exercise, right? That's unusual, right? An individual should not be allowed to come after you through the organization, because guess what? In most cases, the state's going to exercise discretion before they sue someone and go after your private assets. But does that private attorney care about justice? No, they care about their pocketbook.
So they're allowed, because they're empowered by the state. That's one of those exemptions. The state can cut right through whatever legal barriers you've set up. They can pierce the corporate veil and go straight to the heart of of your pocketbook. They can go straight to you.
Exactly.
You can't just file bankruptcy. You can't say, I'm just sue my business. All right, I'm shocked. All right, keep going.
So, and I'm going to use a couple of legal words here, guys, but give me some slack.
All right.
Okay.
And these are terms that everyone knows. We have sued on these bases. It is a violation of separation of powers to do this. And here's why. The legislature has basically said, okay, we're taking away the authority or the oversight of the executive branch. That's wrong.
Right.
That should not happen.
Because the state is supposed to be involved in overseeing this
Well,
lawsuit.
the executive branch has its thing that it does.
And instead they're
The courts
deferring
have
it to
its thing
somebody
that
else.
they've done, but the
Right.
legislature can't say, okay, executive, you can't enforce these laws. I mean, it's not their job to encroach on what
So
the executive
let me throw out a hypothetical. Let's say that the legislator said, we're too busy. There's too many things we got to do. We're going to empower private attorneys to write laws and pass them.
violation of separation of powers.
We're going to hand them our duties and responsibilities because we can't.
Well,
fulfill them.
that would be an improper delegation. But they said we're going to have the governor write the laws. That
Oh,
would be
even worse.
That's
Yeah,
a
right.
separation of powers issue, right? That's not your job. The governor enforces the laws, or the attorney general. The legislature writes the laws, and the courts interpret them. Okay, in doing PAGA, they basically said, executive, don't enforce the laws, let private people do it.
Yeah.
The legislature shouldn't have the power
You exist
to
enforce the law, but you say you can't do it, and you're going to deputize and let ordinary attorneys do this on behalf of some client.
Separation
That's
of powers.
interesting.
Yeah,
Yeah, good. That's very good.
Yeah, so, and again, due process, I will try not to geek out
This
too
guy's
hard
a
on
clever
this.
attorney. You got a
Yes,
good guy. All
and
right.
there's a due process thing. Now, here's what I mean by due
Are
process.
we still on page 2?
No, we're on 5 now. We're on 5. We're making. If you guys would quit asking so many questions, we could get through it.
Well, Paul.
Just summarize today, where are we at? So we couldn't do anything else. We did this, and you're saying the 2 or 3 arguments you made already are what?
Well, due process. The next one is due process, and here's what I mean by that.
All right.
Before you walk into someone's business, before anyone, you have to have an opportunity to be heard. You have to have an opportunity to speak your mind before neutral.
Wasn't that the 14th Amendment that created
14th
due
Amendment,
process?
exactly.
Ooh,
And
wow.
look at you coming right out the gate, and 5th Amendment. And so,
Know your Constitution.
yeah, and so due process, and this is
More
important
should.
because this
Go
comes
ahead.
to our class action argument, and people just assume class actions is a thing. But let's go back and think about that. If I sue Tom for whatever reason, Paul can't come around and say, I want money for the same thing. You got to prove your own individual case.
Right.
That makes sense, right?
Right.
The class action was invented to say it's efficient if Tom did the same bad thing to several people. If we can prove he did the same bad thing to several people, it doesn't violate Tom's due process rights to have an individual argument between each people.
To join up all the cases.
Exactly. And so that's a due process protection for Tom. Okay, everyone's entitled to that. Now, the class
and in a class action, you're also allowed to opt out. If you think Tom's doing a bad job and you want to do your own case, you're always allowed to opt out of it.
Now, PAGA got rid of all class action procedures. It has now violated Tom's due process rights because you no longer have to prove that common question, that common bad. They've gotten rid of it. So that's why it violates
And
due
can an
process.
employee opt out of a PAGA thing?
No, because it's a state action. There is no opting out.
If they opt out, like say they don't cash the check, then the state will collect the money.
Yeah.
But I'm saying, I've had these all the time. I get mailed. You bought a car from some company, or you did business with a bank, and somebody's coming up with a lawsuit on behalf of all of you. And whether you knew or not, you're now part of this class action. If you do nothing, we're going to pursue it on your behalf, and if we get anything, you're going to get a share of it. But if you don't like this, or you don't agree with it, or you want to pursue it yourself, tell us now, and you can opt out.
That is due process of law. You have the chance to opt out, and Tom typically has a chance to litigate against each person, but the class action was invented as a creature to be efficient.
And PAGA takes all that away.
Because there is no due process procedures.
There's no, do the
You don't
people in the class get notified?
Not really. And so, but here's what happened. Here's what's important.
And can they opt out?
So remember how I told you, I think a couple episodes ago, we said, generally speaking, we're all familiar with, if you have a defect in your car, right? And the class action, the class action is for the defect in that car,
right?
Right. In PAGA, it'd be the same thing. If you had a meal break issue, then the lawsuit is about meal breaks. And you have to prove that Tom screwed up. I keep picking on Tom here.
Right.
That Tom screwed up the meal breaks in the same way with respect to everybody. Otherwise, it would violate Tom's due process rights to bring a lawsuit for something completely unrelated.
Right.
PAGA allows that. It says even though someone suffered a meal break violation, I'm going to sue Tom for wage statements. Even
Or
though I
anything
never
else
had a
we
problem.
find, right.
And why?
Under the same lawsuit.
Because the
right.
state can do that. The state is allowed to audit you. By doing business in the state of California, you allow the state supernatural powers. But you can't give those powers to a private attorney who's trying to make money.
And that's what they've done.
And that's what they've done. So that's a due process argument.
Interesting.
Then
We've got a constitutional argument. We had a due process argument. What else?
we also have equal protection. And this goes directly to the...
Page 3 we're on still?
We're on... I'll get there.
Equal
And
protection.
This is going to go a lot faster. I'll
Isn't
take you through the arguments.
That's also the 14th Amendment. Equal protection.
Equal protection.
My God, you really know your amendments.
I do.
Equal protection clause, and that's essentially goes to the exemption we talked about earlier. This year, the construction lobby got themselves exempted from PAGA. And if you read the reasons why, the justifications they put forward are all the same justifications that Tom's company has, that Paul would have. They're not unique. It is an arbitrary exemption for no reason.
It's not just because they do something different and therefore should be treated differently.
It is irrational, and so that's the separation of powers.
So if you're strong enough and powerful enough and want to do a state initiative or argue, you got enough sway, you can either through legislature or through amendments to like.
If you have an expensive lobby, and let's be honest about it, if you go up to Capitol Hill and you spend the money and you fund campaigns, you get an exemption. That's what happened here. We all know that. Just say it out loud.
And how about the hospital? The ambulance drivers. They got sort of an exception.
But they had to go through an expensive ballot. They basically had to go around the legislature and spend $32 million or something.
But your argument is the fact that some can fight to get an exemption is unfair.
Right. Well, the legislature said, and I'll go through it when I go through the reasons why were because they said, well, we're being subject to frivolous lawsuits. Unscrupulous attorneys are bringing all these ridiculous claims. They're expensive and they're meritless. These are all the same complaints that everyone has with PAGA because that's how everyone experiences them.
Right.
So by giving them an exemption for no special reason, that's not equal protection of the laws.
Okay.
And the final one, it's very easy, is cruel and unusual punishment.
Wow, really that far? Okay.
Yeah, well, think about it. A punishment should have some bearing to what you did wrong.
Clearly.
Right? If you're going to be punished for something, and again, this is a state fine. This is not a private litigant coming after you. This is the state saying, I'm exacting penalties from you.
Right.
That should have some
Can't
relation
be
to
onerous
what you've done.
is another legal term. Can't be onerous or too heavy.
You like that word, onerous.
Yeah.
And as we'll get into later, a $28 screw-up, even unintentional, can cost you $68,000 to $8,000. That is cruel and unusual.
68,000?
68,000.
Yeah, we talked about that in the last show.
Yeah, so that is cruel and
That
unusual,
example.
and that's pretty obvious on its face. So those are the theories, and now this will make sense. Now, the first part of the complaint, and I'm not going to spend a lot of time on it, talks about all the wacky things in the labor code. Okay, we go through. And
is that a legal term, wacky?
Wacky, it is, like kaboom. And so we first talk about,
Finally, a lawyer talks in real English here.
Yeah.
Okay.
I like it.
And we talk about meal breaks. So let's talk about what a meal break law is. It's important. The meal break law is this. Before the end of the 5th hour of work, you must give someone a reasonable opportunity. You must provide someone the opportunity to take a meal break. Now, until 2012, we didn't know what the word provide meant. We had to have a Supreme Court case tell us what it meant to provide someone a meal break.
And let me stop here for 1 second. That's what drove me crazy the 1 year I did spend in law school. It comes down to arguing what does if mean? The Clinton's defense against his dalliance, his fooling around here. What does what mean? What does this mean? What does that word? That's critical in so many cases. What does reasonable mean? And what does provide mean? Always arguing over these.
And here's the Supreme Court's answer. The employer satisfies this obligation if it relieves employees of all duty, relinquishes control over their activities, and permits them a reasonable opportunity to take an uninterrupted 30-minute break. Now, here's what's important about that.
Okay.
That
sounds
reasonable to who?
Well, yeah, reasonable.
So if the employee says,
standard.
I didn't feel like I had the opportunity to take a break, can you disprove that was their set of mind? No, you cannot. So no matter...
Say that again, because so the key is you got to give them a reasonable opportunity to take a reasonable break.
Right. So what is a reasonable opportunity? What if someone says, I felt like I had too much...
I was pressured.
The classic example is someone who's hustling, a hustler like a waiter. Do they want to take their breaks? No.
It was unreasonable to force me to do it right then. I'm going to make a bunch of money right now.
Exactly.
And or if they're like right in the middle, they have a great table. They're ready to get a big tip, and then wait a minute, I got to take my break.
When they get fired, all of a sudden, I didn't have a reasonable opportunity to take my break. And because that's a state of mind issue, you almost can never win that lawsuit.
Because as long as they say it, it must be true.
Okay, so those are meal breaks. That's why meal breaks are screwy. Wow. And here's rest breaks. Rest breaks are the most dangerous area of California law right now.
Really? Okay.
Because a rest break must be given the time...
I'm sorry, we got to take a break right now here. Go ahead.
Speaking of rest breaks.
Yeah, so a rest break is this. It's similar to a meal break. You must permit and authorize, that's the language. And again, we had to have a Supreme Court case to tell us what that meant. A 10-minute paid rest break. Here's the issue. There was a recent case that came out, and here are the facts. And we did this in the first episode. We had security guards who basically they were night shift people, and they had to carry a walkie-talkie. It was undisputed. No one argued that they were never paged, they were never called, but because they had to carry that walkie-talkie, they had to it was an on-duty rest break. You described to me a set of facts.
Say that again. So I'm a security guard. I got a walkie-talkie so I can respond to emergencies, and I can't put it down and go pee. I got to have it with me in case something happens, right? They got to be able to call me. So, in fact, I'm still on duty.
Still on duty.
On call, even though I'm eating or going to the bathroom or whatever.
Exactly. And if you describe to me...
sleeping.
Or sleeping.
Describe to me a set of facts where you don't have an on-duty break. Because what's going to happen? 10 minutes is not long enough to walk anywhere. And you're in still a place of employment. there is no way to put a bubble around someone to make sure that no one interferes with them in that 10 minutes. And anyone who has a cell phone, how many managers text people on their cell phones? So,
well, or I've heard other examples. So the waiter is over there eating his meal, and somebody says, "Hey, can I get some soda?" You've interrupted their break. Inadvertently, the customer came over and asked them a question.
Same thing.
or where's the bathroom?
Yeah, where's
Right?
the bathroom?
Where's the
Same thing.
bathroom? Yeah.
So again, in that rest break, it's almost impossible to comply with when you think about it. Okay, so that's a
You'd
rest-
have to isolate. You'd have to take the
you have to
employee.
put them in a bubble.
Right.
You know,
so nobody could come up and suddenly ask them a question.
exactly. And then the pay stubs, we've talked about at length. I don't think we want to do that again.
No, that's
those,
crazy.
we beat that to death. So,
What just go back and listen to the past episode. The problem with the pay stubs is a minor violation. You gave them an arbitrary employee number, and then you type the wrong one in their pay stub. That's enough to trigger a PAGA lawsuit and millions of dollars in fines.
Indeed.
Can't fix it. No harm, no foul, no bad intent. It's meaningless. It's paperwork, but it's enough to trigger this.
right. And then the last one is what we call waiting time penalties.
Are we on what page are we on? Because we're all
11.
trying to. We have everybody following along. Right
11. We're on page 11.
11. Oh my God.
You can find the complaint on the website too.
Trust me, it'll speed up.
cabia.org.
It'll speed up.
Give us the website. You mentioned it. Where is it?
cabia.org.
And somewhere in there you can see this and read it yourself.
Oh, yeah.
You can pull a copy of it.
It's on the home page.
Okay.
So
readers follow along.
on page 10 and 11, actually 11, and these are called waiting time penalties. Now, if for any reason you do not pay someone every penny they are owed, it doesn't matter if it's 1 penny or $1 million, and it doesn't matter if you meant to do it or not. If you do not pay someone every penny they're owed, they make the same amount of money they make on a daily basis for 30 days. And I put a chart on page 12. If you have an employee who makes $11 per hour, that is a $2,640 penalty.
For doing what?
If you don't pay someone 1 penny and it's inadvertent, you didn't mean to do it, then that person they'll make
The penalty is you got to give them 30 days pay.
exactly at $11 an hour. It's $2,600. At $15 an hour, it's $3,600. And again, guilt or innocence does not matter. Intention.
So
does
these
not
aren't
matter.
in proportion to the crime. The punishment doesn't fit the
And
crime.
we haven't even gotten to PAGA yet.
Wow.
Remember, because PAGA is only triggered if you trigger these. That's why we're doing this.
Yeah, right.
Right. You have to trigger one of these to trigger PAGA.
You got to have a violation or a perceived violation, and that opens up the door for them to dig and look more with the power of the state.
Exactly.
And to stack them all up, and then to threaten you with a massive atomic bomb, way out of proportion to whatever you may or may not have done, technical violations, and you settle.
That's right. Now, did you want to continue on to the history of the law, or do you want to take a break? It's up to you.
Let's take a break for a second
we can
because
keep
my
rolling,
my head's spinning already here. All right, let's take a quick break, come back, and wrap up and see. I want to talk about what are the odds of it. Are we just tilting at windmills here, or is there a real chance of this
we
working?
can get to that. We feel good about it.
Okay, all right. Stick around, folks. All that and more when we continue to examine this cutting edge, this first of its kind lawsuit on behalf of small business owners and big business owners alike.
You need to fight with us.
Fight with us. Join us. We'll talk about how you can do that, too, and support this thing. That's the other point I want to get across right after this.
Imagine what it would feel like to lose everything: your job, your home, your family, your dignity. This has happened to thousands of the men, women, veterans, and young adults we serve at Working Wardrobes. What do we do to help? We provide career development services, life skills workshops, job skills training. We provide the perfect interview outfit, and we get clients placed in jobs. Call Working Wardrobes, 714-210-2460. Donate, volunteer, invest, hire.
All right, there. A little public service announcement we threw in there just to give us a break to take our breath, catch our breath. So you've gone through all the legal arguments you've made on constitutional grounds, on such things as equal protection, and what else? Give me some due process and some other things. These are the stuff you always hear in lawsuits against government entities. They're not following the Constitution. Now what? What else were we missing out of this? You still haven't talked about PAGA itself. These are just the things that
We're going to
trigger.
get into the PAGA law itself. And again, this law started in 2000. It was passed in 2003. It became active in 2000.
Because all these other things are saying somehow that it's not the law itself, but it's the fact that you're giving the power to, you're relinquishing the role of the administration or of the executive branch to oversee these things. You're it's undue process, it's not fair, it's all these things that you're talking about. But the law itself, you haven't get into anything and saying this is stupid.
In 2003, the California legislature said, look, we don't think there's enough compliance with the law. So what we're going to do, rather than try to enforce the law ourselves, we're going to allow every single employee in California to step into our shoes.
And sue their boss.
And sue their boss. And they'll get these special privileges and these special status.
Stellar powers.
Exactly. And so...
Special rules.
And keep in mind, at the time when this happened, California had the largest employment department in the country. Still does. And so, and when this law was passed, again, it was passed by the barest of margins in the Senate, in the Assembly. So a very small number of people in California gave us this law. And what's important, and we touched on this earlier, because Tom did it in the intro, this is an unprecedented transfer of power to private people. And there is no example like it anywhere in the world.
Except
if you commit a hate crime. It is the only place in any law, anywhere, where the state gives its power to a private person to pursue and deter hate crimes. And that's the only analogy they could come up with.
Well, that really puts it in perspective.
Really?
Really does.
And so... we'll move forward. So the history of the law, there's a bunch of legislative history, and I encourage you to read it because it is terrifying. Because the thing about it is, the legislature kind of wrote our complaint for us. They knew this would be a problem. They knew what the arguments were. They knew it would be abused, and they passed it anyway. So this is not something they didn't see coming.
We've done a lot of research, Paul.
Wow,
and part of that research has found it to be more disturbing than we thought initially.
So let's do that in a future episode. I don't want to slow us down, but I think that would be fascinating for those history buffs like me who'd like to hear about how this thing came about, who came up with it, and how they, in arguing it, foresaw many of the potential abuses and did it anyway. Go ahead. Right. All right, so you're pointing that all out. Maybe that'll mean something to court, maybe not. But the court is still got to consider, is the law something that can be challenged? Yeah.
Right. So, and let's be clear, the Supreme Court has looked at this law in an isolated way.
Supreme Court of California?
It did.
Yeah.
And it said it was constitutional in the Iskanian case. And what happened there was someone said this law is they didn't directly challenge the law like we did. They raised it as a defense to other claims. And the court didn't have a brief like ours, had no discovery on it, there were no facts on the ground. No one said, look at all these lawsuits.
But their initial, and was that a unanimous thing, or was there dissent?
I can't remember if it was unanimous or not, but the point is that they didn't have their record before them. And what's important is our lawsuit is challenging this lawsuit as applied. Let me explain that. If you write a law that says you cannot work here if you're a certain race,
right,
that is unconstitutional law on its face. You
right,
can tell from the language itself that's not a good law.
Right.
If you write a law that says you can't work here if you have a criminal conviction, and it happens that people of color have more convictions, as applied, that law can be unconstitutional. Right, the way that's used
because it discriminates against one group.
On its face, it looks fine.
You came up with another reason not to hire people of color.
But the language of the law doesn't. There's nothing wrong with the language of the law. It's how it works in practice.
And
that's our challenge.
Right.
We're saying on the face of the law, yeah, if on the face of the law, probably it could be okay, but the way it's being used, it results in an unconstitutional delegation of power and all these due process violations and all of that. So I
wouldn't have even given them that.
Again, because we're coming at it we're leading with our chin here, right? We're acknowledging what the Supreme Court's already said and say, but you didn't look at our facts. You had no facts in front of you.
Yeah, and that's the point. You have to take into account what they've already ruled, what little they've done.
For those following along, what page are we on? 19?
On page 19, if you want to understand PAGA better than most attorneys in the state of California,
and most of your fellow business owners,
read page 19 through 24.
And what do I find in those 5 pages?
And that is how the PAGA law is structured, the penalties, what's done. So this is how a PAGA lawsuit works. You have a violation. They go to an attorney. The attorney sends a letter to the state, and
announces that they're going to sue under this statute on behalf of the state and everybody else.
And in less than 1% of the case, in less than 1% of these letters, does the state even look at it.
Because
the state has acknowledged it.
Because they only got 1 or 2 people doing this for all of these thousands of lawsuits.
So in less than 1%, and then the state never shows up again.
But that's let's stop for a second there, because that's one of the things I don't understand. Doesn't the law state a process? Under due process, it has to be a process. So you, employee, think you've been wronged. You go to an attorney. They say, forget about that, but let's go to your pay stub and your work breaks. That's where we can get this guy if you want to nail him. And then they have to become a PAGA lawsuit, to bring the state in and all the special rules and the special power that adds to this. They have to notify the state. And doesn't the state have to sign off and oversee this?
No, indeed, in the state is
just
upfront
they don't even
about
have to prove them that they got it. They just say, you notify us and you're done.
Exactly. And I encourage people, although it's not in the complaint, under the OSHA PAGA law, completely different. If the state doesn't do anything on the OSHA side, you have to go to a court and compel them to do it.
Yeah, right, exactly.
Okay, you have to say, you know what? The state didn't do anything about this OSHA violation. Make them do it, state, not in PAGA, because it was written by trial attorneys. They don't want that. So
the mere notification, if they send a certified letter to the state, whether the state even
first and last
gets
time
it,
the state's involved,
sees it, looks at it, they don't have. You've now assumed the power of the state without them overseeing it, approving it, or even being involved in it.
Exactly. And that is
exactly that's
the complaint, you guys. I mean, we could go through all the other parade of horribles. That is a first.
How can that be lawful? How can that be lawful to bring this power of the state?
Lawful.
Well, they're involved when they cash the check.
Right.
Well, yeah,
here's
Tom.
And the only other possible time is when there is a settlement or a court verdict.
What did you say? I'm being
snarky.
Snarky today.
Snarky
There
today.
is when a settlement is filed, you must deliver a copy of the settlement to the state. They don't have to review it. They don't have to do anything. They must. If they get a copy, there's no other action.
But if they were going to allow me to go jail people, let's give another extreme example. If I was going to be deputized to go round up people and throw them in jail, you think they would, one, have to be notified, and they'd have to approve that, say, what are you going to do with this power? And then they'd have to have some oversight to it. It can't be unlimited because I might do it wrong.
Exactly, and that's our complaint.
No oversight.
Is that if you're going to give the state power to people, you must oversee how that power is used.
Yeah, otherwise it's abused, and it has been. All right, so I want a couple minutes left. That's an amazing summary of a very complicated argument, and I appreciate it. I encourage people to go back and listen to it again.
Since I'm snarky today,
go ahead.
Can I mention in our complaint we're gonna refer to them as the Dirty 30.
The Dirty 30.
The Dirty 30.
These are the 30 top firms who figured out they can make a heck of a lot of money for doing very little.
Absolutely, boy, you hit that one on the head. You hit what page is that one on? As we're following along,
it's on page 35
on our romantic dinner.
And so to qualify that statement, we took data from the state. The state has provided us this information, and we have looked at the law firms that have sent the most PAGA notices.
Right.
And since 2004, the law offices of Rahman Yunesi has sent 753 PAGA notices.
Well, don't start naming them here. Then they're going to call me up and...
It's a public document. Right. And so...
Kingsley and Kingsley, number 2, how many?
599. And you continue. And so these are...
Are these big firms, little firms? Does it matter? Are these just... Is this all they do?
It's a remarkable amount of use of the state's power.
That a handful of people are
again,
doing. Because they figured out... They figured out how to do this.
All our complaints
they
says
figured out how to game
if you're
the
going
system.
to allow these law firms to act on behalf of the state, oversee what they're up to. Pay attention. Make sure they're doing the right things. And I'll make one personal example. I have a case right now. It's a pro bono case that we're handling at Epstein, Becker, and Green in conjunction with Morrison and Forster with my colleague David Walsh. It is a organization that provides housing and medical care for people with AIDS.
Seemingly good group of people, all right.
I have not one, but 2 PAGA lawsuits against it for violation of meal breaks. Now, if the state was enforcing its own laws, do you think the state would have an interest in pursuing them for meal breaks and rest breaks?
Is this who they want to be attacking?
And that's the point. And to that point, we've also listed a number of what we call sympathetic people like this in our complaint, starting at page 37.
Page 37.
We're talking about hospitals, children's hospitals, labor unions.
So it's not just evil, awful people like Tom Manzo who are out there trying to screw over his employees and trying to
making them take a lunch 20 minutes past 5 hours.
You slave driver, yes.
So again, no one is immune from this law. And again, if you're going to give power to the state, pay attention. These type of people probably should not be being sued.
Right, can't be unlimited, can't be you got to oversee it, and somebody's got to make sure that on behalf of us, that power is not being abused, because there's oversight and checks and balances in every other part of the system, but none in this. All right, I get it. Now, are we wasting our time?
Not at all.
Got any hope
Not
whatsoever?
at all. we feel very good about this complaint. We believe that the facts speak for themselves. And indeed, this complaint is what we call mostly self-proving. We've cited to legislative
self-proving. Res ipsa loquitur. The thing speaks for itself.
Wow! Oh man!
We've spoken. So most of this complaint speaks for itself. But more importantly, we feel very good about getting past the first stage of litigation.
And let's talk about that for a second, because the first stage is in many cases the heart. That's where they try and tear it apart on its merits.
I have a great analogy for this.
All right.
You've all played that game at the carnival where you have to knock down the milk cans with the balls, right?
Right.
So in law, you typically get 3 throws.
Right.
The first one is called a demur. I know it's a legal term, but let me explain what that means. Tom and I, we actually have a lunch date today, and we're supposed to go get lunch after this podcast.
Right.
If I peace out, I ghost Tom.
He's going to give you a lunch break.
And he walks into court and says, Rob flaked on our lunch appointment. The court's going to say, there's no law that punishes Rob for that. Even if everything Tom said was true, we had an agreement, we were supposed to meet, and I flaked. Even if all that is assumed to be true without proving it.
He can't sue you because you didn't show up for lunch.
There is no law that's a demurrer. That is what you
demurrer?
Demurrer, yeah.
So they would say on the face of it, that's not a suable offense.
Exactly.
Sorry, Tom.
What you've stated, even if they agree with everything in our complaint is true, the law does not protect or does not prohibit this conduct.
So they're going to try and find out if there's if there's anything here that they can throw it out. This isn't something you can sue for.
The law does not. Yeah, this is not a legally sufficient.
This isn't a legal issue.
Argument.
Right.
The next thing is summary judgment, and that is if we agree on this is so. Let's say Tom gets now. This is a criminal offense, but it's the easy one to use.
Right.
Let's say that Tom gets a ticket for going through a light.
Right.
And remember, if the cop says Tom was driving, the light was red, he ran through it at demurrer, that cop he would lose, right? Because the law does prohibit that conduct, so
right.
So that would be sufficient complaint.
The cop wouldn't lose. Tom would lose. He
Tom
could say
that's
exactly, he's allowed to write you a ticket for that.
But summary judgment, we get to figure out what are the facts. The facts are undisputed. If it's undisputed that Tom was driving, the light was red,
and he ran through it,
he loses. Now, if it's undisputed that Tom was driving, the light was green, he went through it, Tom wins. Now, but what if there's a dispute of fact? And
right.
that's when we get to a jury. And the dispute
right.
of fact is this: was the light red or green?
Right. But
that's what a jury gets
so if
to
there's
do.
no dispute as for the facts, the judge can move to an immediate summary judgment. This doesn't have to go to trial. It's a suable. There's a legal case here. The facts are not in question. Make a judgment.
Apply the facts to the law. Facts apply to the law. One side wins.
And that's what you're asking for, a summary judgment?
Well, we'll see. We'll take it any way we can get it.
Okay, all right.
So we want to have a bench trial on this, but but more importantly,
they don't want to have a bench trial on this.
More importantly, we will. I truly believe we will survive all the stages. But
now, let's talk about the other ones, though. Do you have standing? That's the big one. Okay, so there's a violation here, but what gives you the right to sue on behalf of whom?
Without getting too legalese, we have what's called associational standing. This is an organization comprised of members who they could sue in their own individual capacity, and this organization exists, among other reasons.
We represent the class.
We represent the class. And so, and if necessary, we could find a representative step in an actual organization.
Somebody who's actually been harmed. And
exactly.
Has there been a harm? You can sue all day long, but if there's no harm, there's no foul.
And let's go. So some people say, well, guess what? You've been hit by a PAGA lawsuit, but that might not happen in the future. Where's your harm? I take you guys back to Roe v. Wade. Because pregnancy could happen in the future. If you could be harmed by something in the past and it ends, because that's typically what happens, right? You have a lawsuit, but the harm ends before the lawsuit can finish. It takes forever to finish a lawsuit.
Yeah, exactly.
But if the harm could be repeated upon you, then you have standing. Same thing could happen. You could be hit by a PAGA lawsuit. It could be over
again
before
and again
we
and
finish.
again. I see.
That would be so we would.
So
have
you can't stand
then.
up and say I was done wrong, and the law says, but it's over.
If you could only be sued once under PAGA.
If you're suing me to change the law, then prove that that you have some potential harm in the future.
If you could say PAGA was never enforced again in the future, we wouldn't have standing. But because it could be enforced against a business again, you have standing.
I see. All right. So standing, I know, is for procedural grounds. They try and rip it apart. There's nothing to be. There's no there. There's nothing to be sued about. If the facts are clear and undisputed, you could go to a summary judgment.
That's the key, Paul. See, this is what's really exciting. We get to serve discovery on the state, and we get to make the state admit that they don't look at these things. Admit that you lose these notices.
And
Admit that
that's what I was hoping
mediation.
we would get to, because people say, why go through all this? Win, lose, or draw, you're going to get
We're going to shine a big, ugly light on a big, ugly law.
Yeah.
And they're going to have to turn over that information. And
There you go. That's
very,
what now
very
Tom's smiling.
embarrassing.
Yeah.
Oh,
For the-
I know.
It's
And
gonna be
Rob is
super
just
embarrassing.
into it, huh?
Yeah,
Wow.
I'm living for this. So
Has anybody sued on behalf of this and lost? Is there any? You say
no one's directly attacked PAGA like we have.
the underlying merits of the law and its constitutionality, and in so doing, if you pass the first step and it does get certified and whatever they do, and to say yes, this can go forward.
If we beat the demur,
all the motions to stop this thing, which they'll inevitably throw up. If you get through that and it's a lawsuit, then what happens? Then you start having discovery, and they
we
got
get
start.
to ask them a bunch of very embarrassing questions, and then the questions they don't want to answer.
And
we're
is that
gonna publicize
discovery?
it.
I was going to say, does that become public information then?
It's public discovery.
All of it. Just like this document. It's public information.
Right.
Wow.
I mean, if certain things.
So maybe in win, lose, or draw, this will at least shine light on it and
it'll
allow you to
educate
gather
people as to what
information.
this law is doing and what the state is not doing. More importantly.
So how are they going to fight it, other than if they can't prove that you don't have standing and there's no crime?
They'll try the associational standing challenge. They'll also try to say the Supreme Court has ruled that it's constitutional. Of course, our rebuttal to that is that was on an as-applied, that's an as-written challenge, so why we went over that. Ours is as-applied among these other bases. The Supreme Court never looked at due process. It never looked at equal protection.
They never looked at these issues. They might have ruled it in one area.
Separation of powers is the only thing they looked at.
And it was, you're looking at it as it's applied, not as it's written per se.
We do think it's unconstitutional as written because, again, they didn't have a full record. This was just a side argument someone made.
Right.
And again, it's hilarious. If you read the opinion, they cite a rule of court that says, even if you don't brief this, we can rule on it if we think it's important enough. They basically admitted they had no record to rule on.
How about another thing I always hear, amicus briefs, friend to the court brief, where somebody else says, we just want to support this.
We're going to get a lot of those. And on both sides, by the way, because these trial attorneys do not want this to go away. Right. So when it goes up to
it's a source of income for them to defend.
Some of them, it's all they do.
Why is your company doing
some
this?
People go to law.
You defend these all day long. This might hurt your bottom line here.
Exactly.
I haven't heard or seen so much Latin since I watched. I think it was Bugs Bunny, the Roadrunner.
They used to do a lot of Latin. Yes,
exactly.
Latin on that. I studied Latin. I'm sorry to admit, I'm a good Irish Catholic. I studied
amicus.
Latin.
That's wow.
Amicus brief.
Amicus.
Friend of the courts. Law's filled with all these legal terms here. I guess I'm just curious to see where this goes. What time frame? When did they have to respond? When will we know if this is going to move forward?
We filed a complaint on the 28th. Typically speaking, under the California Code of Civil Procedure, they have 30 days to file.
28th of
last month. So
last month, because people are going to hear this as a podcast later. So last month being when?
Oh, November. So by the 28th of December,
November of 2018.
And 5 days before that, they should give us a call to meet and confer. So we should be hearing from them sometime soon to say, look, these are the problems we think you have with your complaint. We're going to say take a hike, and they're going to file the demur, and then we got to fight.
Any other big law firms going to come forward and say, yeah, we support this? Anybody, other
That's
big
what
associations?
We want. Right now, we want associations. We want law firms.
We want
nonprofits.
All the support. Do the right thing. Help us change this law. Help us beat this law.
And how do they reach
Radio
you?
stations?
Yes. How do they reach you if they want to join
the law
in?
firm that is heading the charge at Cabia's discretion is Epstein, Becker, and Green.
Okay.
My name is Robert Pepple, the lead attorney on the case, a guy who I emulate, despite some of his foibles and flaws, is Rich Fry. He's a genius. He does the right thing. He's a man of intense personality and character.
Who else do we have on the complaint?
We also have Paul DeCamp, who was the former head of the Federal Department of Labor, so a good guy to have on our team.
Wow, okay.
And my good friend and a very capable man, David Prager.
All of you are going to try and fight this through to conclusion. And
it's the dream team.
It's the dream team ready to fight. Okay, we got the dream team. Are you going to eat gloves that you're going to hold up here? And
it's the right thing to do.
If the law doesn't fit, you must quit.
I like that. Let's leave it there, folks. We're going to try and tune in from time to time. So you'll come back. The next time we should hear from you is when? We're talking November and December of 2018, right?
I would hope within a few weeks.
We should, unless we grant an extension, we should see their demur before New Year's Eve.
So January shows we should be able to come back and say,
here's what they're trying to do.
Here's what they're trying to do.
And here's what we're doing. Because we're going to continue to fight this. I mean, we need to change this law. We need everybody to stand behind it. cabia.org.
And we need the money to pay
Join.
for this.
Absolutely.
This is not cheap, folks. Airing these grievances in such a fashion is an expensive, particularly if it does turn into a prolonged fight here. We need a defense fund. You need money to support this
And that's
cause.
where it's all going. I'm not taking any wages. Nobody at CABIA is taking any wages. It's all going towards that.
Wow. All right. Give us the website again, cabia.org.
cabia.org.
And can people donate? Is there a defense fund that they can donate, or do they just join the
CABIA?
Join. You can donate.
Among
All of
other
it's on
things,
there.
this is not the only thing CABIA is doing. It's its current focus right now, but CABIA was basically incorporated.
So
to
there's a fee,
train.
and then you can join CABIA, and the money that you pay goes towards things like
And
this.
we do
And
trainings. We
this
come
public
regularly,
outreach,
yes.
obviously, we're renting the studio time and doing all this stuff to help pay to tell the voice and tell the message and all these things we're doing here.
Yeah.
All right. I'm just amazed that you guys have taken this big step. Have others discouraged you from doing this, and why?
Well, that's where Rich Fry's leadership comes in. Rich is the only guy that had the courage to do this. It is a very, very aggressive move. And, the Rich and Tom, they're dangerous when they get together. You should hear them banter.
Yeah.
But they're doing the right thing. And so, yes, people discourage us from doing this. And
Even other associations dropped out and said, no, this is too scary for us here.
Right.
Why don't you try? All you're going to do is piss
And
off
even
everybody.
some larger
here.
members are worried, hey, I don't want to be affiliated with, I don't want to have problems with the state. People need to quit being afraid of it's
Doing what's
our
right.
government. It's
Yeah.
our government.
Yes, right. That's a good point. And we're afraid of them. We're afraid to challenge them because you can't fight City Hall. All of a sudden, the fire department's going to show up at your door.
And remember, under PAGA, they can come for you too. And that's what I didn't mention. That law where they come after you personally, you don't have to be the owner of the business. You could be the person that processes payroll, and they can come after you personally.
That's right.
Wow.
They're going to come for you too.
Then we can't sit silently on the sidelines. We've all got to join in. That's why we have here at the station. That's why others are coming forward here. And we need your help. We need your support to tell this story, to fight this fight, and to make enough politicians pay attention to what it is. PAGA reform
now.
All right. That's where we're going to leave it for now.